Welcome back to Norton Rose Fulbright's Texas Business Court Insider. Don't forget to hit like and subscribe to get notified when we post a new video analysis. I'm Rafe Schaefer, and with me today is Andrew Price. Andrew, what do we have in store?
Well, we've got a special episode today, Rafe. September 1st marks the one-year anniversary of the Texas Business Court. And we at Texas Business Court Insider are going to do a few episodes, a bit of a retrospective, looking back at all the Texas Business Court has accomplished in this first year.
That's right. So for this first video, we're going to dive into the Business Court's Primexx case, which is actually the first business court case that went from filing to final judgment, and it did it all in 9 months. Andrew, can you give us a Primexx primer?
Absolutely. So the allegations in the Primexx case was a limited partnership dispute. So it was a private equity investment in a limited partnership. And the plaintiffs were the minority unit holders in Primexx. And they alleged that Blackstone and some other defendants affiliated with Blackstone entered into a self-serving transaction with Callon Petroleum. And essentially the allegation was that the defendants had accepted a lowball offer that benefited the defendants and destroyed the minority's interest in Primexx. So these minority investors sued the defendants and alleged that the defendants had breached various statutory and contractual duties in forcing the sale of the company in this lowball procedure.
And although the business court portion of Primexx took place over a span of 9 months, the procedural history goes back quite a bit farther than that. Primexx originally sued in December of 2022 in Dallas County District Court. Blackstone originally answered that lawsuit, but moved to dismiss based on a forum selection clause. The Dallas County District Court granted that motion to dismiss in March of 23. Primexx then sued again in federal court in the Northern District of Texas in May of 2023. That case was later dismissed by the federal court for lack of subject matter jurisdiction. So Primexx went back to Dallas County District Court and sued again in July of 2023. And this time Blackstone filed a special appearance. So Andrew, how did we get from that background to business court?
Well, when September 1st, 2024 hit, the parties in this case, and you and I are familiar with this, Rafe, they tried an agreed removal or an unopposed removal. And so right after the business court opened its doors and began accepting cases, on September 27th, there was a removal and the defendants in the case consented to the removal. But as watchers of our videos know, this was a hot topic by the business court, and all the judges were very concerned about their subject matter jurisdiction. And the judge said, wait a second, this is a pre-9/1/24 case. I don't think I have subject matter jurisdiction. I need you guys to brief it for me, even though this is an agreed removal. And the parties in this case apparently decided, rather than fighting that issue, as I'm sure they started to see the opinions roll out that said you couldn't remove pre-9/1 cases, instead of fighting it, they just decided to non-suit the case and refile in business court. We don't have a lot of detail on this, but I think we can assume there must have been some sort of tolling agreement entered into. The bottom line is these parties really wanted to be in business court, and they got in business court through a refiled lawsuit directly in business court on October 25th, 2024.
Yeah. Once the parties got back into business court, Judge Whitehill in the Dallas Business Court Division wasted no time getting to work on the case. Judge Whitehill authored 5 written opinions in less than 6 months. The first opinion written by Judge Whitehill was a denial of Blackstone's special appearance. The opinion came out on February 10th, 2025. Effectively, the opinion held that because the Blackstone defendants, or most of the Blackstone defendants, had initially appeared in the 2022 Dallas County District Court case, that they had waived their special appearance in these next filed Primexx lawsuits that followed on from that first case.
Right, and so after tackling some of the procedural issues around personal jurisdiction, Judge Whitehill jumped into the merits, and there was a motion for summary judgment. The judge issued an opinion on that on March 10th of 2025, and it's a great opinion, and everybody involved in commercial litigation in Texas ought to read it. It's a lengthy discussion and analysis of Texas policy of freedom of contract principles, applying it in this case specifically to partnership agreements. And the court acknowledges, look, partners have a wide latitude to expand or limit their contractual duties. There are duties such as loyalty and care that cannot be completely eliminated. And in this case, that was basically what the partnership agreement had said. It had broad waivers of various duties and had limited the duties that do exist to basically the confines of the law. They didn't expand those duties beyond what the law says they are. And so based on these contractual disclaimers, the court largely dismissed the plaintiff's claims other than some claims related to straight breach of contract with regard to how the funds from the sale to Callan got distributed to the partners. The plaintiffs were unhappy with that decision, and they moved to reconsider and asked Judge Whitehill to look at it again. He wasted no time in disposing of that. A month later, the motion for reconsideration was denied. And in another opinion, Judge Whitehill went on and kind of said, look, the record itself negates every instance of lack of good faith or bad faith that is being alleged by the plaintiffs. And basically the plaintiffs didn't have any evidence put forward to demonstrate a lack of good faith. But Judge Whitehill wasn't done, and neither were the defendants. Taking that ruling, the defendants filed another motion which said, well, we now want to extend your reasoning to all of the other related affiliates of Blackstone who are non-signatories to the actual contract, but are within the definition under the partnership agreement of affiliate. And so therefore the contract applies to the affiliates as well. And Judge Whitehill took that up again in short order. May of this year, he issued another opinion agreeing with Blackstone and applying the summary judgment logic and decision from earlier in the year to Blackstone's affiliates based upon what many of us would recognize as a typical definition of affiliate in one of these, partnership agreements, LLC agreements, corporate agreements. Broad definition of affiliates. The defendants fell under the definition, and Whitehill had no problem applying the logic of his motion for summary judgment to the affiliates.
Judge Whitehill still wasn't done. He came back about 6 or 7 weeks later in early July, and he issued another special appearance order. I had mentioned the special appearance denial for most of the Blackstone defendants. There actually were two defendants, Blackstone Inc., and then a Blackstone side individual who had been added to the later filed suit. They also filed a special appearance, and because those two entities hadn't generally appeared back in Dallas County in 2022, Judge Whitehill granted their special appearance and dismissed the claims against them for lack of personal jurisdiction. So in all of that time between February 10th, 2025 and July 16th, 2025, Judge Whitehill authored and issued 5 separate opinions on special appearances and motions for summary judgment. What happened next, Andrew?
Yeah, as our watchers might imagine, there wasn't a whole lot left of the plaintiff's case by this point in time, but there were a few claims remaining. And so what's interesting is the parties essentially agreed that these, I guess I'll call them more minor claims, they agreed to go ahead and non-suit the remaining claims, and basically the parties agreed to that so that they could take a final judgment in the case and go and take up the more substantive claims related to the summary judgment. That's what they did. And on July 9th of this year, the parties then appealed that final judgment. And now you've got an appeal of a final judgment. Some of these special appearance rulings that you previously mentioned are also up on appeal. And again, a lot of that's, if not fully briefed, in the process of being fully briefed. And I would expect the 15th to take that up in short order.
And so looking at the resolution of Primexx, we've mentioned this 9-month period. In that 9 months, the business court held 8 hearings, issued those 5 written opinions. The opinions totaled 172 pages, authored and issued by the court between February and July of 2025. The MSJ ruling itself was 79 pages. The 2 special appearance rulings were 35 and 41 pages. And the court was able to get to complete resolution in 9 months of a case that had otherwise been bouncing around from court to court and jurisdiction to jurisdiction since 2022.
Right. And so that's really why we wanted to talk about the Primexx case, right? Because when the business court was established, the one of the core principles, Rafe, was we need a specialized court with experienced judges where sophisticated parties and experienced counsel can have their matters resolved efficiently and capably. And so Primexx really is a barometer for litigating in the business court and the promise of the business court. Will it be an outlier? I don't think so. I think it's going to be more of the rule than the exception. As we've covered in some of our other videos, there's local rules in the business court regarding timing, 18 months for jury trials, 12 months for bench trials. And I guess I would also tip my cap to the counsel on both sides in this case. Obviously, they wanted to be in business court. They made that happen, and they all worked very, very hard to achieve an efficient resolution. And it's a good example of sophisticated lawyers and litigants working to get the crux of a matter teed up and resolved in an expeditious fashion.
Thanks for joining us today. Stay tuned. Our year in review series will continue in a couple of weeks with our next part of our year in review video series that's taking place all September. Thanks for joining us.